Okay, welcome to the first Holman Web Insurance webinar of the year. All of you are on mute, but we'll be taking questions which you can type into the chat box or the question box, I'm not sure which it's called. We'll be attempting to answer all the questions today, but if we can't, we'll be distributing the answers that we do give today and any unanswered questions with a link to the recording of this session later in the week. Most of the cases we'll be looking at today are from the New South Wales Court of Appeal. They're from 2020, obviously, thus the name of the seminar, 2020, a year in review. The first one that's of some interest to a number of people I know is HDI Specialty and Wonkana, or as I like to call it, Business Interruption Insurance v COVID-19. The second case, which we'll be covering, is Capar and SPG, which is a case involving liability for an axe-wielding intruder. Tapp and Australian Bushmen's Campdraft and Rodeo Association on the issues of obvious risk, recreational activities and risk warnings. Bauer Media, the Khedrlarian on liability for workplace processes. Lee and Strelnicks on others on what will hopefully be the final instalment on credit hire. And finally, from the High Court, more v Scenic Tours on whether damages for disappointment are caught by the Civil Liability Act thresholds for non-economic loss. We're putting up some questions for two reasons. One, to make sure that you're all still awake, and second, to keep you engaged. The first question, which I think Bill is going to put up for us, is what is the name of the Commonwealth Act governing the declaration of COVID as a listed human disease? Is it firstly the Insurance Contracts Act, the Quarantine Act, the Biosecurity Act, or the Infectious Diseases Act? The people who are physically present need an answer. Anyone close that poll, Bill?
Still collecting responses.
Okay. We might close the poll now. Okay. So the correct answer was the Biosecurity Act 2015. So one of the first things that I think many business owners did when COVID-19 locked us down was to look to see whether we had any insurance for losses that we expected would follow. Business interruption policies obviously vary from insurer to insurer, but a number of them had or have an extension providing cover for outbreaks of infectious disease causing business interruption, or for prevention of access to premises, for example, arising out of various lockdowns. However, those covers were usually subject to a right-back or exclusion in respect of certain diseases. These proceedings were brought as a test case. The Insurance Council of Australia agreed to pay the costs of the business owners on a solicitor and client basis. And apparently this issue affects over 250,000 business interruption policies in Australia, and the business interruption claims in Australia are estimated to be worth $10 billion. So it's a reasonably significant issue. The insurers involved were HDI, who issued a business interruption policy for a tourist park business, and Holman, who issued a similar policy to Thrive Health and Nutrition. Each of the business interruption insurance policies, as I've said in the slide there, provided cover for interruption or interference caused by outbreaks of certain infectious diseases within a 20-kilometre radius of the insured's premises. In both policies, the extension was subject to an exclusion. That exclusion being the cover does not apply to any circumstances involving highly pathogenic avian influenza in humans or other diseases declared to be quarantinable diseases under the Australian Quarantine Act 1908 and subsequent amendments. The Quarantine Act, of course, was repealed, as many insurers now know, repealed in 2016 and replaced with the Biosecurity Act 2015. On 21 January 2020, COVID-19 was determined to be a listed human disease under the Biosecurity Act. What this highlights is probably the need to keep policy wordings constantly under review to ensure wordings keep pace with legislative changes. I actually made the effort of going to find the determination that listed COVID as a listed human disease, and it was described in these terms by the then Director of Human Biosecurity, Dr. Brendan Murphy, to Section 4 of the Act, after G, yellow fever, add human coronavirus with pandemic potential. It would seem that potential might have been somewhat of an understatement, but anyway. So the question that the court was asked to resolve, the New South Wales Court of Appeal was asked to resolve, was were the reference to diseases declared to be quarantinable diseases under the Quarantine Act and subsequent amendments to in fact be construed as extending or referring to diseases under the Biosecurity Act 2015 on the basis either that the Biosecurity Act constituted a subsequent amendment or that the references to the Quarantine Act were obvious mistakes which should be construed as if they were or included references to the Biosecurity Act. The court referred back to comments of Chief Justice Rixon in Halford and Price as to contractual construction. The printed parts of a non-marine insurance policy, and usually the written parts also, are framed by the insurers, and it is their language which is going to become binding on both parties. It is therefore their business, that is the business of the insurers, to see that precision and clarity is attained, and if they fail in this, any ambiguity is resolved by adopting the construction favourable to the insured. Now, most of the insurance nerds present will be familiar with that rule, namely the Contra Preferentium rule, which is to be applied in the case of ambiguity. So, in determining that COVID trumped over the business interruption policies, Marr and Ball adopted this approach. The exclusion adopts a specific mechanism provided for under the Quarantine Act and no other. The possibility of that act being repealed was real and would have the consequence that the machinery at least may not have any ongoing operation from the time of its repeal. The wording does not address that possibility, and they felt that to suggest that the words and subsequent amendments included the enactment of the Biosecurity Act is many steps too far. Hammerschlag, with whom Justices Bathurst and Bell agreed as to the contractual principles of construction, and these are also rules which are well known to people involved in insurance. The age-old adage, an insurance policy is a commercial contract and is to be given a business-like interpretation. It requires attention to the language used by the parties, the commercial circumstances which it addresses, and the objects which it is intended to secure. The meaning of the words chosen, and this would be a good checklist for people when looking at any policy interpretation question, this and the following slide. The meaning of the words chosen is determined objectively by reference to text, context and purpose, the question being what a reasonable person, and for business insurance policies probably including their reasonable business person, would have understood them to mean. Preference is to be given to a construction supplying a congruent operation to the various components of the contract of insurance, and so as to avoid making commercial nonsense. They continued, if it is clear on the face of a written contract that an error has been made, that the literal meanings of the words used by the parties is an absurdity, and if it is clear what the self-evident objective intention of the parties was, and it is clear that what correction is to be made to cure the mistake, orthodox canons of constructions will displace the absurd literal meaning by a meaningful and sensible one. But the approach, they said, is to be distinguished from rectification equity. It's premised on absurdity, not ambiguity, in which case the Contra Preferentium rule would presumably apply. It applies even where the language used by the parties is unambiguous. It doesn't apply where to give the words their literal meaning brings about a result which is simply inconvenient or unjust, but not absurd. And it doesn't give the court a mandate to rewrite an agreement so as to depart from the language used by the parties, merely to give a provision in operation which it appears to the court might make more commercial sense. But the court noted that the dividing line between that which lacks commerciality and that which is absurd may not always be a bright one. And this is particularly so, as is the case here, where the words are not incoherent, and the court felt the exclusion still had work to do because the diseases which had previously been declared under the Quarantine Act were still declared because the repeal of the Quarantine Act didn't affect anything that was done properly under that Act. Now, I said this was in the New South Wales Court of Appeal. It has had an application made for special leave to the High Court, and there was a little bit of discussion this morning about whether or not anybody would be putting bets on the insurers winning. I don't think there were many who thought that was the case, but you never know. The special leave application by the insurers advances two key arguments. Firstly, whether the Biosecurity Act should actually be regarded as an amendment to the Quarantine Act, and it's argued that this was consistent with the commercial intention of the parties, namely to exclude diseases so serious that they move the Commonwealth to impose special quarantine conditions. The second issue raised in the special leave application is that the contract can be corrected of mistakes by construction, but as the submissions note, it should be clear that something has gone wrong with the language, and it should be clear what a reasonable person would have understood the parties to have meant. As I say, whilst they're good arguments, it's probably doubtful that the insurers will succeed, but if nothing else, a fresh determination from the High Court on the manner in which insurance contracts are to be construed, or for that matter commercial contracts to be construed, will be a significant development in case law, I would have thought. So we move on to the next question, which is, can a defendant be liable in negligence if the risk cannot be avoided by exercising reasonable care? The possible alternatives are yes, no, or it depends on which court you're in. Give people a little bit of time to put in answers to that. All good, Bill? Okay, I'll move on to the next slide then. The answer to the question is no, for the reasons that you'll see in a moment, because negligence necessarily requires it to be something that you could reasonably have done to have avoided the incident. So Capar and SPG Investments. In March 2010, Mr. Capar was employed as a security guard at the Lidcombe Power Centre. Early one morning, he detected an intruder entering the premises. By the way, it wasn't the first time that an intruder had entered the premises, and he went to investigate, and that was part of his role. When he confronted the intruder was wielding an axe and threatened to kill him. Mr. Capar escaped, police were called, the person was subsequently detained, but Mr. Capar suffered mental harm as a result of that encounter. He brought proceedings against the owner of the premises, SPG, and the provider of security to which he was subcontracted, Business Protection, and also against his employer, Dynamite Security. At first instance, he lost against SPG and Business Protection on the basis that the presence of an intruder in the premises was the materialisation of an inherent risk under Section 5I of the Civil Liability Act, or the defence that's provided by purportedly provided by Section 5I, as you'll see in a moment. Interestingly, the first instance decision was widely commented upon and was said to have reinforced the principle that, except in unusual circumstances, occupiers and employers will not be liable for injuries to security guards where the injury is caused by criminals. It was clear to the New South Wales Court of Appeal that each of the defendants owed a duty of care to the plaintiff. The previous break-ins should have alerted each of the defendants to the weaknesses in the perimeter security of the centre, and all of them should have taken steps to deal with those weaknesses. But it's the analysis of Section 5I that I thought was the most interesting part of this decision. Section 5I, which in some respects formed the basis for the question at the beginning of this case discussion, was that a defendant has, or a person has, no liability for materialisation of an inherent risk. A person is not liable to negligence for harm suffered by another person as a result of the materialisation of an inherent risk. And an inherent risk is something occurring that cannot be avoided by the exercise of reasonable care and skill. The section doesn't operate to exclude liability in connection with the duty to warn of a risk. Justice Baston, with whom Justice McCallum agreed, had this to say about Section 5I, which I think is delightful. The idea that a person could owe a duty of care in respect of a risk which cannot be avoided by the exercise of reasonable care sounds like an oxymoron. That's possibly because it is. It is possible that this is not so because the formulation of the duty and the identification of the risk may occur at different levels of particularity. However, the possibility that a defendant could be held liable for breach of a duty of care in respect of a risk, materialisation of which cannot be avoided by the exercise of reasonable care, is clearly incoherent, and in practical terms, Section 5I is otiose. So SPG, as owner of the premises, had a responsibility for physical security and had knowledge of the roller door gap vulnerability. Business Protection, as a subcontractor of SPG, took responsibility for training security staff and defining the operations to be carried out, upon which security staff, upon which the security staff acted. The instructions didn't contemplate that the plaintiff would take an entirely passive role, and him going out to investigate was appropriate in the circumstances. Notably, Justice Emmett dissented in this decision. He said that the duty of an occupier of a building is to take reasonable care for the safety of the persons in the building. The content of that duty in this case did not extend to protecting a security guard from the risk of an intruder. I think what's interesting about the decision is the effective rejection of Section 5I as ever being a defence to anything. But anyway, so the next case that we're going to be looking at, and the question that we're going to put up, is who gets the benefit of the volunteer defence under Section 61 of the Civil Liability Act? A, the volunteer personally; B, the organisation for which they volunteer to; or C, Homer Simpson. I think it's Homer Simpson. Just wait for people to put in some answers to those questions. All good? Okay. So the answer to that question will become apparent in a moment, but Tapp and Australian Bushmen's Campdraft Rodeo Association Limited involved Ms. Emily Tapp, who was then 19 years old and was participating in a Campdraft event at Elliston in New South Wales. The event was organised by the association. She fell from a horse while competing and suffered a significant spinal injury. And quantum was agreed in the matter at first instance at $6.75 million. So it was obviously a very significant injury and obviously significant to Ms. Tapp. Camp drafting, I've included the description here for those who don't know what it involves. I didn't. It involves riding a horse at high speed, I think normally chasing cattle or the like, often at full gallop around a course which has pegs. It involves the rider steering the horse around the course, and there are obviously a number of risks, not the least of which is simply riding a horse, but the horse could fall by losing its footing or contacting the hooves of the animal being chased. The rider could lose balance and fall off. Horses and animals are all unpredictable, and those were some of the reasonably obvious risks of being involved in camp drafting. The plaintiff had been doing it since she was 6 years old, So she was obviously very experienced. However, the plaintiff failed to establish what had caused the horse to slip and fall, and in particular didn't establish that there was a deterioration of the Campdraft surface which would have warranted a suspension of the event or other action. Now that was one of the defences which was also pursued by the defendant was obvious risks of dangerous recreational activities, and as you can see there from section 5L, a defendant is not liable in negligence for harm suffered by another person as a result of the materialisation of an obvious risk of a dangerous recreational activity. One would have thought that the risk of falling off a horse is an obvious risk of a dangerous recreational activity. For example, recreational activities are defined but relevant to this case include any sport. The Court of Appeal held that, assuming that it had been established by the plaintiff that her horse had fallen by reason of a deterioration in the Campdraft surface, that would nevertheless have been a manifestation of an obvious risk of the dangerous recreational activity. That is, the risk of the horse slipping and falling was an obvious risk, even if the plaintiff didn't personally know of that risk. So even if she'd gotten up on establishing that the deterioration of the surface had occurred to a level where the event should have been stopped, she still would have lost because it was a manifestation of an obvious risk. That's probably not the most interesting part of the case. The parts of the case that I found more interesting were Tapp, were the risk warning which was given. Excuse me. The risk warning that was given was in the same terms as a risk warning given in Men's and Wagga Wagga Show Society, and that decision was handed down shortly before the Tapp decision, as a result of which the defendant in this case did not rely upon the risk warning because it was in the same terms that had already been decided in Men's. But as you can see from that purported risk warning, it was not so much directed to informing competitors of the danger, but extracting from them an acknowledgement of voluntariness and an indemnity. A similar form was completed, as I say, by Ms. Tapp, but in Men's, the court held that there was a very good reason to doubt the efficacy of the risk warning, in part because of the generality of the description of the risk, which they felt fell short of satisfying the requirements of section 5M, namely, or 5M5 or subsection 5, namely, a risk warning need not be specific to the particular risk and can be a general warning of the risks that include the particular risk concerned, so long as the risk warning warns of the general nature of the particular risk. This risk warning, as you can see, doesn't refer to any of the particular risks of the event in which the claimant was engaged, and perhaps also because it wasn't shown that the Agricultural Society of New South Wales was acting as the agent of the Australian Bushmen's Campdraft and Rodeo Association. But what they did rely on the risk warning for was as evidence of the reasonable precautions taken by the defendant in satisfaction of the duty of care owed. The court in Men's sensibly said, I might just hold there for a second, we might have some audio.
Somebody said that the audio cut out. If people can't hear John, can they just drop us a question? Hopefully it's just one person.
Okay. So in answer to that proposition that the risk warning could be evidence of reasonable precautions taken in satisfaction of duty of care owed, the court in Men's said, if a risk warning is effective, no duty of care is relevantly owed. If a risk warning is ineffective, it seems, I thought this was clever, it seems strained to say that a reasonable precaution against a risk of harm is to force a participant to sign a form. Probably reasonably common sense. The next interesting part about Tapp, though, is the volunteer defence, which was the subject of the question that I asked at the beginning. Section 61 of the Civil Liability Act provides a protection to volunteers in the terms that are on the slide. A volunteer doesn't incur any personal civil liability in respect of any act or omission done or made by the volunteer in good faith when doing community work. It was contended by the association in Tapp that they had the benefit of that defence because their liability arose vicariously through the acts of its members who performed the work voluntarily. However, the association was an incorporated association and as such not a natural person. The Court of Appeal affirmed that the personal civil liability equals volunteer, and that volunteer can only be a natural person. I would add to this, though, that the incorporated association will be in a very different position from an unincorporated association, which there are still a few of, in which, in the case of unincorporated associations, the proper defendants are in fact the members of the unincorporated association who will be able to rely upon the volunteer defence. So we'll move on to the next question, which is, as against an employer, if a system of work has a risk of injury which can be avoided by not doing the job, is the employer liable for the injury suffered? Yes, no, or it depends on what the alternative is. All right, we might carry on. So Bauer Media and Khedrlarian, plaintiff was employed, as many people are these days, by a labour hire company, Demand Personnel Proprietary Limited, and she performed work at the premises of Bauer Media. She allegedly suffered injuries to her neck, shoulders and wrists, and she alleged that they were the result of a failure by Bauer and Demand to provide her with a safe system of work. Bauer, for those of you who don't know, is a magazine publisher and distributor. Printed editions of magazine titles would be delivered to their premises, where the orders of individual news agencies would be compiled and bundled before being distributed. And that was the task in which the plaintiff was engaged. So the plaintiff's role primarily involved selecting the number of magazine titles required for each order, placing them on the conveyor belt. There were, however, other tasks which the plaintiff could have undertaken, such as labelling the bundles, and workers were in fact encouraged to change tasks periodically. There'd been no previous or subsequent claims of injury from the same process, and in the district court, perhaps curiously, the only particular of negligence that was pursued or identified was a failure to ensure a proper system of task rotation took place to reduce or eliminate the risk of injury. The New South Wales Court of Appeal unanimously allowed an appeal from the judgment that had been entered against Bauer in the first instance, and also against the employer. They referred there, you see the quote, "No conclusion of negligence can be arrived at until first the mind conceives affirmatively what should have been done." That's from a 1924 judgment of Chief Justice Isaacs, as he then was, in Metropolitan Gas Company v City of Melbourne Corporation. The matter was heard before Acting Judge Curtis in the District Court, and he said in his judgment finding in favour of the plaintiff, the obvious precaution available to Demand personnel was to refuse to supply the services of the plaintiff to the defendant until job rotation was introduced. That imposed no burden. Well, it turns out the Court of Appeal thought it did impose a bit of a burden, and I think perhaps there was some criticism of the judgment as well. Pardon me. The New South Wales Court of Appeal said, capitalising the term job rotation did not identify with any greater precision what it required. The proposition that the employer should refuse to place any person with the appellant in that part of its packing process would clearly have destroyed part of the employer's operation. So that would seem to have been the burden to which the Court of Appeal was referring. And they said, in the absence of evidence as to a precaution which should have been taken by a reasonable designer of the system of work, being a precaution which was shown to obviate or reduce the risk of injury to an acceptable level, a finding of breach of duty was not open. So the only solution which it would seem was able to be advanced on behalf of the plaintiff in this case was that that because the system of work had a risk of injury, that meant that they should simply refuse to do that work and not do it until there was no risk of injury. It's perhaps also a cautionary tale for plaintiffs that you can't simply assume that suffering an injury in a workplace is sufficient to establish liability and negligence. And probably also a good example of why not to run a case before acting Judge Curtis. So the next question, it involves credit hire. If an innocent third party's Ferrari is damaged and the third party establishes a need for a vehicle, is the negligent party liable to pay for A, a Ferrari, B, a Toyota Corolla, or C, public transport? Public transport? All good? Okay. The answer is unfortunately Ferrari, but it depends a little bit. There's 4 cases that ran in the Supreme Court at first instance and then returned to the New South Wales Court of Appeal. They all involve credit hire. For those of you who don't know what credit hire is, it is the provision of a vehicle on credit to an innocent party involved in a collision whose vehicle is being repaired, and it's provided whilst the vehicle is being repaired. It has become an increasing problem for insurers over probably the course of the last 10 to 15 years because it has led to an increase in the cost of many of the claims. But likewise, it's also led to many insurers now offering more mainstream solutions to their insureds by way of replacement vehicles when accidents happen. The question posed in each of these cases was, especially in respect of prestige vehicles, where a claimant has a need for a replacement vehicle, what constitutes reasonable expenditure on hiring that replacement vehicle for the purpose of determining recoverable damages? Now, the first question, which you can see that I've put there, is that you have to establish need. Need for the use of the damaged vehicle. And you'll see this from one of the cases that I'll show later on, if the claimant wouldn't have had any need to use the damaged vehicle during the period that it was being repaired, there's no entitlement to damages. The next question, though, is what style of vehicle is the innocent party entitled to? Is it like for like? That is, Ferrari for Ferrari. Unfortunately, the answer is yes. So there were 2 helpful commentaries on what the cost of hiring a replacement vehicle should be based upon. Firstly, Justice Emmett, the cost of hiring a replacement vehicle that is equivalent in as many respects as possible to the damaged vehicle will be the means whereby the claimant is put in the position which he, she, or it would have been but for the wrongdoing. The loss that the claimant suffers, which gives rise to the relevant need, is the deprivation of the use of the damaged vehicle, not simply deprivation of the use of a means of transportation. The loss will not be compensated by a replacement vehicle that simply provides the same form of means of transport. So no on the Corolla, which on this point had been such a winner. It had been the standard against which replacement vehicles were judged very much, but it would seem that's not the case any longer, and that's confirmed by Justice White. It can be inferred that the plaintiff will have a reasonable need for a commensurate vehicle, a reasonably equivalent vehicle, a reasonable substitute, or a broadly comparable replacement vehicle. And then he completely nailed it when he says, the loss suffered by a plaintiff who has lost the use of a prestigious vehicle is not merely the inconvenience of not having a vehicle, but the loss of a vehicle which has the safety, luxury and prestige of the damaged vehicle. Notably, he commented upon how the burden of proof changes during the course of proceedings involving replacement vehicles. He says, once the onus of establishing need is discharged, the onus of establishing whether the particular replacement vehicle that was hired was unreasonable then shifts to the defendant. And that was interesting in the context of a couple of these cases, because obviously unreasonableness can take a number of different forms. It can include the rate charged, and that the measure of the rate charged is the market rate, but that market may be quite limited when it comes to prestige vehicles, and especially I would think in the replacement vehicle or standard hire market for vehicles with companies like Avis, Budget and Thrifty, they will perhaps be less inclined to have a large fleet of prestigious vehicles available for hire, given the travel restrictions on tourism. It's worth noting the evidence called is critical in these cases, particularly two of those cases, Lee and Strelnicks. The plaintiff didn't establish need. The Court of Appeal accepted that the evidence wasn't sufficient to establish need because she didn't give any details other than what the court described as the most general motherhood statements of needing a replacement vehicle for family purposes and taking children from place to place and visiting friends. She didn't give any evidence of where she worked and where she travelled to and from. And even more fatally, perhaps, in Souaid and Nahas, which was one of the four decisions, the local court's finding was that the plaintiff in those proceedings actually said he was content with any car, and that meant that that he did not require a prestigious vehicle as a replacement vehicle. Any vehicle would do. So that brings us to the next and final question, which is, are damages for distress and disappointment for the breach of a contract damages for personal injury? Okay. So the answer to that question is was considered by the High Court in Moore v Scenic Tours. I think I actually, perhaps in the 2019 year in review, I did Moore and Scenic Tours as a decision of the New South Wales Court of Appeal. Anyway, it went to the High Court. Representative proceedings were brought in the Supreme Court against Scenic by Mr Moore on behalf of himself and 1,500 other passengers of 13 Scenic cruises. There was obviously some very unhappy customers for Scenic cruises. The river cruise was promoted in Scenic's tour brochure as a once-in-a-lifetime cruise along the grand waterways of Europe, with guests on board the Scenic vessel treated to all-inclusive luxury. Unfortunately for Mr Moore, and it would seem a number of other travellers, their cruise was severely disrupted by adverse weather conditions. Instead of cruising for 10 days, as scheduled, Mr Moore's experience was of many hours spent travelling by bus, and he cruised for only 3 days and then had to change ships twice, and it wasn't aboard the luxurious Scenic Jewel. The proceedings were brought under the Australian consumer law on the basis of, I think, 3 breaches of implied guarantees. Firstly, the failure to exercise due care and skill in the supply of the tours, in breach of Section 60, in breach of the guarantee from Section 60. Secondly, that they were unfit for purpose and that they were not of the nature and quality promised, in breach of the guarantees in Section 61. It was said that Scenic knew or should have known about the weather disruptions that were likely to occur and didn't give their customers time to cancel, or didn't inform them that they could cancel in a timely manner. The matter was first heard before Justice Garling in the Supreme Court, who found that Scenic had breached the guarantees, but he held that Section 16 of the New South Wales Civil Liability Act, which caps damages, didn't apply to damages suffered overseas, and he awarded a sum for distress and disappointment. It's important to note here that you might wonder why this New South Wales Civil Liability Act applies to an assessment of damages under the Australian Consumer Law. The Australian Consumer Law, by I think Section 275, imports the operation of the state legislation governing awards of damages. And in the case of a contract formed in New South Wales, that was the New South Wales Civil Liability Act. So the New South Wales Court of Appeal upheld the finding that Scenic had breached the ACL guarantees. It agreed that Section 16 of the Civil Liability Act was picked up and applied by Section 275. However, it disagreed with Justice Garling that the CLA didn't apply to an award for damages suffered outside Australia. They said it governed the awarding of damages in New South Wales by a court or tribunal. So they felt that Section 16 did apply because it applied irrespective of where the damages were suffered. Rather, it applied to how a court or tribunal in New South Wales may award damages. Accordingly, the New South Wales Court of Appeal didn't give Mr Moore any damages because he didn't exceed 15% of the most extreme case for disappointment, and accordingly the award of damages was set aside. Matter went to the High Court. The High Court agreed that the New South Wales with the New South Wales Court of Appeal, that Section 275 of the ACL picked up and applied Section 16, but it disagreed that damages for disappointment and distress occasioned by a breach of contract were damages caught by Section 16 of the Civil Liability Act. The High Court in this regard reaffirmed Baltic Shipping and Dillon from 2012, in which the general rule that was stated was that damages could not be recovered for injured feelings caused by a breach of contract. The exception to this, however, was where the damages were being awarded for distress, vexation and frustration, where the very object of the contract has been to provide pleasure or relaxation. Such a claim, they said, was to be distinguished from claims where the distress and disappointment was consequent on physical injury. And I think I possibly presented on Insight Vacations at one point as well. Insight Vacations was a claim where there was distress and disappointment which was consequent on physical injury. And for those of you who might remember the facts of it, it involved a lady in a bus. The bus came suddenly to a halt and she hurtled down the corridor of the bus, suffering injury. And that would have been a claim where the distress and disappointment was consequent on physical injury. But Mr Moore made no claim that he'd suffered any physical injury, nor any recognised psychiatric illness by reason of his experience. Accordingly, the High Court said that the damages which were awarded to Mr Moore were not subject to the threshold imposed by Section 16 because they were not an award of personal injury damages, which is all that Section 16 of the Civil Liability Act governs. As a final note on this case, although they were representative proceedings, they did involve a number of other potential claimants, the amount of damages that were awarded and which the High Court were considering was the princely sum of $2,000. You have to wonder why it was worthwhile running all the way to the High Court for that. But anyway, I'm told that there are a couple of questions. I'll see what I can do to answer those. One of the questions is on credit hire. Does that mean that the innocent party is able to decline their own insurer's replacement vehicle and get a credit hire one if it's not a prestige one? I think the answer to that is potentially yes, because the court of the New South Wales Court of Appeal says that the measure of damages is a similar vehicle to the one which they had, and so they'd be entitled to go to a credit hire provider, get a prestige vehicle, and claim that from the at-fault party. I think though the reality often is that where people get a replacement vehicle often by their insurer, they often just go with that. And I think probably pretty unlikely that people would go out of their way to seek a prestige vehicle. I could be wrong about that, but another question in relation to the market rate: are the courts awarding damages based on daily rates or considering tiered or weekly rates for vehicles? That's a very good question. It wasn't considered in that case, but I think there is previous authority that the appropriate rate is the tiered rate and not daily rates, because the injured party is assumed to be taking reasonable steps to mitigate their loss and take, therefore, tiered rates rather than daily rates. So I hope that answers those questions. With the car hire one, can we argue that a prestigious one was not necessary as it was not required for work? Example, I don't know whether there's more to that question that I can't see. But I think the answer to that is no. If they had a prestigious vehicle and it was replaced by a reasonably similar prestigious vehicle, it's not a question of necessary, it's a question of whether they establish a need. If they establish a need, they're probably entitled to like for like. Do you think special leave will be granted in the business policy pandemic case to the High Court? If so, what is, oh, thank you, Margo. What is your assessment of the prospects of success for the insurer? Well, as I said, I think at the outset, I don't think the insurers have particularly high prospects, but I wouldn't be betting money on it. I think special leave will be granted, though. I think it's a matter of such significance that the High Court will want to look at it. So yes, I think that answers that question. There's a question there in relation to the horse riding activity, in relation to the horse riding claim Tapp. Does the fact that the activity is a dangerous recreational activity allow the occupier operator to escape liability even if they are found to be negligent in failing to maintain the ground/equipment? I think what the New South Wales Court of Appeal was saying in that case is that if it is the manifestation of an obvious risk of the recreational activity, then probably not. But I think there were some significant problems with the evidence that was called by the plaintiff in relation to the reasons why the horse slipped. But as I said, the Court of Appeal said she would have lost anyway because it was the manifestation of an obvious risk. So hopefully that answers that question. Lucy's asked a similar question to the one that somebody else has already asked. So, all right. Thank you everyone for attending. There will be another presentation in either late April or early May by Peter Bennett, who will no doubt give a much better account of himself than me. And just a reminder that a link to the recording of this session will be sent to all of the attendees later in this week. Thank you very much for your attendance.